तो जो भी आपके मन की इच्छा है उसको लिख लीजिए ताकि 2 मिनट में हम अपनी बात को रख सकें, ताकि ज़्यादा से ज़्यादा लोग रख सकें। अब मैं आमंत्रित कर रहा हूँ राजपूत जी को। आप सुप्रीम कोर्ट में आप तैयारी करेंगे, वो स्विचेज ऑफ कर रहे हैं। सुप्रीम कोर्ट के आप एडवोकेट हैं, लंदन स्कूल ऑफ इकोनॉमिक्स से आपने मास्टर्स की डिग्री की है एंड पीएचडी कर रहे हैं आप इन्वेस्टमेंट आर्बिट्रेशन में सिंगापुर से। स्पेशली इसी कार्यक्रम के लिए सिंगापुर से फ्लाई करके आए हैं हमारे अनुरोध पे, हम उनका धन्यवाद करते हैं। और मैं ये समझता हूँ कि 370 एक नए परिप्रेक्ष्य में शायद आपको देखने को मिले नेक्स्ट 10 मिनट्स में।
व्यासपीठ पर विराजमान सारे मान्यवर माता भाई और बहनों, मुझसे अनुरोध किया गया है कि मैं एक पावर पॉइंट के माध्यम से अंग्रेजी में अपनी बात रखूं, इसलिए मैं आपकी अनुमति से अपनी बात अंग्रेजी में करूंगा। Frankly speaking, Jammu Kashmir is not a problem. The problem is the misinterpretation, misunderstanding, distortion of facts, realities, and the true nature of Jammu and Kashmir. It shall be my effort in the next 10 minutes to try to put to you that Jammu Kashmir is not a problem and what is the true nature of Article 370 of the Constitution of India. Next. The first point which I need to make is that Article 370, the journey of Article 370 starts with Article 306A of the draft Constitution of India. When this Article 306A was being deliberated in the Constituent Assembly on 17th of October 1949, Gopal Swami Iyengar, who moved the motion, made it candidly clear, in very clear terms, that this is only a transitionary provision. And therefore, since I am at paucity of time, so I won't read his entire statement. This is at page 495 and then 427 of the Constituent Assembly debates. Very, very candidly says that the only reason why we have put this provision in the Constitution of India is that we want very soon normalcy to be restored in the state of Jammu and Kashmir. A Constituent Assembly of Jammu Kashmir needs to be constituted, which will fully extend the Constitution of India. The moment the job of Constituent Assembly of Jammu Kashmir is over, utility of Article 370, draft Article 306A was to come to an end. This was the death time of Article 370. Unfortunately, that was not happening. In any event, now let me move on to what is the true nature of Article 370 of the Constitution. It falls in chapter 21 of the Constitution, and the title of the Constitution is, of the chapter is Temporary, Transitional and Special Provisions. First two words are important, temporary, transitionary. I don't think there is any need of clarifying as to what is the meaning of temporary and transitional. The only concern arises with the word special provision. Is special provision word applicable to Article 370? The answer is a clear no. Because when 370 and chapter 21 was inserted, at that juncture, there was only Article 370. Subsequently, in order to implement Article 13th Constitutional Amendment of 1962, there was a constitutional amendment made and a special word of special was added in the time. And this special word was limited only and only to Article 371 onwards. And therefore I have the statement of objects and reasons which says, in further to the agreement reached by government with Naga peoples, so it was relating to Northeast, limited only and only to Article 371A and subsequently to I. It has no relation to Article 370 of the Constitution. Now let's see the title of Article 370. In Keshavananda Bharati Supreme Court has said title is an important aid in interpreting the constitutional provision. It only says temporary provision, it doesn't say special provision. It puts the point beyond doubt that it doesn't have any special status. Now let us see what is the nature of Article 370. 371A says that Article 238 of the Constitution will not apply to state of JNK. At the moment, there is no such article in the Constitution of India because it has been removed. It simply means Article 371A is a redundant, useless, non-existent, inoperative provision of the Constitution of India because there is no Article 238. There is an important point to be made here because there are certain provisions which are redundant in Article 370. The point I will make it later. This is just the text of Article 371B. I won't read it in full. I'll just explain what is the meaning of it. Certain speakers in the first session tried to say that the Indian constitution does not apply, or the central government cannot make any law for the state of Jammu and Kashmir. With great respect to all of them, it's a misunderstanding, misapplication of Article 371. 371 in clear words says that you can apply the central legislation. And for those who don't know the constitution, there is something called the 7th schedule of the constitution. And in the 7th schedule, the central government can make laws for the union list and for the component list. And this goes on to say, this goes on to buttress the point, make further the point, that the Union Parliament can make legislations subject to two conditions. The first condition is, whenever you are making a legislation relating to defense, external affairs and communications, which were the grounds on which the instrument of accession was signed, whenever you are making any legislation on any these three points, you have to simply consult the state government. Means tell them this is what we are planning to do. That's it, nothing more than that. But if you are doing anything apart from these entries, then you have to have the concurrence of the state government, which is simply an additional legislative mechanism, which doesn't give any special status to Article 370 or to the state of Jammu and Kashmir, which has been wrongly stated, told to us, and we have wrongly followed it under wrong misapplications. Then, the next point which I wish to make is Article 371D is the most important, is the touchstone of this constitutional provision. It says provision of Article 1 and this article shall apply in relation to state. Article 1 says, I have it reproduced here, but 1 says India, that is Bharat, should be union of states. And in Article 1, sub-article 2, it says describes the territories, adds it to a schedule. The territory of Jammu and Kashmir has been added to the Union of India. How can anyone today even think, contemplate to make an absurd argument that Jammu and Kashmir doesn't belong to India? How can anyone think of an absurd argument further that it is not one of the parts of the Union of India? This provision puts it beyond any sort of doubt that it is just like any other state, Maharashtra, Gujarat, Nagaland, Northeast, it stands in the same stature under the constitutional provision as any other state in the Constitution of India. Then Article 371D stirs a lot of controversy as to how far can the Constitution of India can be applied. It says that Constitution of India relating to those 3 points which I made already, that is communications, defense and external affairs, you only need to consult the state government. For any other provision, you can simply go ahead and apply the Constitution. There's only a different mechanism of applying it, and the mechanism is that the President is supposed to pass a presidential order. And thankfully to us, almost most of the Constitution today, which exists today, has been applied to the state of Jammu and Kashmir, and there can be no doubt that it is applicable today. 370 sub-article 2 has been subjected to a lot of misinterpretation, which says that after Constituent Assembly of Jammu and Kashmir was constituted, all central laws had to be certified by that Constituent Assembly. So what happens after the Constituent Assembly is out of sorts. The first point is the reason of Article 370, the life of Article 370 ended the day the Constituent Assembly of Jammu and Kashmir finished its job. It should have been thrown out of the Constitution, but it was not done for whatever political reason. But that simply doesn't mean that 370 becomes permanent. It simply means we are carrying a dead man on our back without any reason, and we need to drop him as early as possible. Now let me deal quickly with Article 373, because that is the kernel of my argument and that is the most important aspect of today. Can Article 370 be removed? Absolutely, because it had to be removed. It was thought it has to be removed. And therefore it says, next slide, it says in very clear words that irrespective of anything contained in the Constitution or anything contained in any other provisions of this Act, once the President of India thinks that Article 370 is not required, the President may, liberty to the President, the President may issue a presidential order and throw Article 370 out of the Constitution of India. He can amend it, he can throw it out. There is only one proviso which creates a little bit of stir, and it says that this should be based on the recommendation of the Constituent Assembly. The argument is there any Constituent Assembly today? On the last day, 1957, when the Constituent Assembly finished its work, the last statement is Constituent Assembly is dissolved. Constituent Assembly is not like a parliament which can be reconvened when and as and how you like. Constituent Assembly is a sovereign body. The way it finishes its functions, you cannot reconstitute. We are not living in Egypt where they have a constitution after every 19 years. So we are living in a country where you have constitution once, and once it is made, no further constituent assemblies can recreate constitutions. So that is a very clear fact. The proviso therefore is a redundant, useless, inoperative, unnecessary provision of the constitution, needs to be chopped off, completely forgotten, and the effect therefore is that as a part of the body of the first portion, the President of India needs to simply pass an ordinance, sign it, and remove Article 370 from the constitution. There is another way. And the another way of doing is Article 368 of the Constitution, which gives supreme powers to the Parliament of India to amend the Constitution the way it wants, subject to the basic structure doctrine. J&K can't, any obstruction of treating J&K can't be a basic structure of the Constitution of India by any stretch of imagination. And therefore, under 368, which gives wide power to the Parliament to amend the Constitution, by following the procedure under Article 368(2), which simply requires a majority whereby 2/3 of the present and voting have to pass the resolution. The moment the bill is passed, Article 370 can be removed. And further, Article 368(5) says there is simply no limit on the powers of the Parliament. So where we stand today, the conclusion, rather way to end my point, is simply this. Firstly, we need to make our mind very clear, 370 is temporary and transitional, not a special provision. Article 370 is only additional legislative mechanism to support an objective, but it doesn't give special powers, special status, autonomy, or any such absurd word which can be used to describe the state of Jammu and Kashmir. And the last point is, the President has the power to remove it from the Constitution the day it wants, and we hope we can create a public opinion where we have President who can simply stand, sign a document and say that there is no need of Article 370 of the Constitution of India.